This is Transqat. What is Transqat? Transqat is a safe space. It's a place for respectful conversations about transgender issues. It's a place for queer people to come tell their stories. I'm host Clare McCarthy. Welcome to Transqat. Back in episode 43, I spoke with Jessica Kohut and Robin Trepanier of Connecticut's Commission on Human Rights and Opportunities. Today, I'm speaking with CHRO attorney Michael Roberts, and we're taking a deep dive into the case of Soule et al. V. Connecticut Association of Schools et al. At the heart of this case are two transgender athletes. At the time, they were high school students. And since 2013, Connecticut law has affirmed that denying trans athletes their rights is a violation of Title IX. This case began during the administration of the 45th president, and then Secretary of Education Betsy DeVos threatened to withdraw federal funding if the state didn't amend its policy. This litigation, as Michael explains, has extensive ramifications and is ongoing.
My name is Michael Roberts. I'm an attorney at the Connecticut Commission on Human Rights and Opportunities. I've been there for going on 11 years. I started as an intern while in law school. Then I spent about a year and a half doing investigations exclusively. And then since 2015, I've been in an attorney role. Most of my work these days involves appeals and court litigation on all of the subject areas that the CHRO covers. And
we talked at length about that with Robin, and I'm forgetting what number podcast that was, but we'll put it in the show notes. Where did you go to law school?
I went to UConn Law School. Yes. Double Husky, UConn for undergrad, UConn Law School as well.
I am an accidental double terrier. My high school was the Terriers, and it was humiliating because, you're this yippy little dog. You're not intimidating anyone. And then I went to Boston University for my undergrad. I had great 4 more years as a yippy little dog.
Small but mighty.
Well, welcome. We were hoping to talk about a couple of things today, particularly let's start with the Soule case because I know you were involved with that. Let's see if we can't come at that chronologically. Andrea Yearwood and Terry Miller are high school students here in Connecticut. This is the late teens.
Yes.
They are trans women. They are also athletes. And that's where the confrontations come in. A lawsuit is brought forth by 3 cisgender female athletes who felt that they were unfairly deprived of advancement, acclaim, accolades, and money because they were defeated by these 2 runners. The ACLU takes up their case. How does CHRO get involved?
The case itself is brought by the cisgender athletes in court. They are represented by an organization called the Alliance Defending Freedom, which is responsible for, among other cases, the recent 303 creative case at the United States Supreme Court, many cases that involve efforts to curtail, limit, roll back rights for the LGBT plus community.
Right. And who are, not to step on you there, but and who are listed with the Southern Poverty Law Center as a hate group.
That's correct. That's correct. We're going back now almost exactly 4 years to early 2020 when this lawsuit is filed. The lawsuit is not the first step in the story of this litigation. Before the lawsuit was even filed, these plaintiffs had sought to obtain a remedy from the Federal Department of Education. Again, this is going back to the previous administration.
Right.
They thought that they could get a favorable and quick resolution there.
Well, under 45, Betsy DeVos was the head of the Department of Education and was very amenable to things like that.
That's correct. Unfortunately for them, it didn't occur as quickly as perhaps they might have liked, and so then they went directly into district court. They named as defendants the Connecticut
The CIAC.
Connecticut Interscholastic Athletic Conference, and as well as a number of local school boards of education pertaining to both the schools where the plaintiff cisgender athletes were enrolled, as well as where Andrea and Terry were enrolled as well.
When you say they file, what is it they want? What if they had won, and I'm using air quotes there, what would they have gotten?
Well, that's still been part of the history of what's been litigated so far in this case. But broadly speaking, what they appear to be seeking is monetary relief. Mm-hmm. At the time, they were seeking an injunction because they were all still in school and we were about to start spring track season.
Right. And since Andrea and Terry are both sprinters, we're not talking cross country, right, which is much more laid back about things.
Yes.
But high stakes track and field with an eye towards college athletics.
That's right. And so the plaintiffs were seeking an injunction to in some way prohibit Terry and Andrea from being able to compete on the girls' teams. And then also some relief that would have changed the existing records to place them one or two up, as the case might have been.
The monetary thing is interesting to me. I mean, obviously, that's kind of part and parcel. Well, as someone outside the law practice, it seems like that is part and parcel of any lawsuit brought is people want money. But it feels a little bit like you're saying, I was entitled to win that race, and I didn't, so give me money. And all of the arguments about testosterone and chromosomes and endogenous versus exogenous puberty aside, that's not something that sits well with me. I was a competitive runner for 10 years, got my ass whooped by many a female runner in many an age group. There is no point where as an athlete you should be feeling I'm entitled to win this race or I'm entitled to hold this record. How does something like that fit into the arguments that you guys brought?
To sort of finish laying the scene of the players involved, so we have those named defendants, and then the CHRO is the state civil rights agency, and the ACLU is a national and longstanding civil rights legal organization. The CHRO moved to intervene in the case on the side of the defendants, sort of upholding and defending the policy that exists that allows students to compete in Connecticut in accordance with their gender identity. The ACLU moved to intervene on behalf of Terry and Andrea.
Okay, I see.
Also on the side of defending the policy. So from our perspective, of course, we are on the defense side opposing the claims for monetary relief. But not to make the case for the plaintiffs, but in general terms, the argument appears to be that if they had won or ranked higher in the competitions, that they would have potentially been entitled to more scholarships or other opportunities that would have come with some monetary amount.
So maybe being scouted by a school that wasn't looking at them at that point.
Correct.
Okay.
And now we know with the passage of time, of course, because 4 years have elapsed, that many of those plaintiffs have gone on to obtain scholarships to continue to compete at the collegiate level. And so if we ever get to the point where we have to actually come to some calculation of what monetary amount will have been lost, that's certainly going to be part of the discussion of how do you quantify I should have gotten more than I did still get.
I remember just vaguely being 18 and waiting for those college answers to come back, and I got turned down by a number of schools, and I remember feeling I deserved to be accepted there. I could perform at that level, not as an athlete, but just as a student. And so I do understand that sense of I should have, but that's not necessarily grounded in reality. So this is February of 20?
January, February timeframe of 2020.
Okay,
yes.
so this lawsuit is brought, and the ADF, or as I prefer to refer to them, the ADNTF, the Alliance Defending Not Transgender Freedom, they take these cisgender athletes on a tour of all of the far right-wing media so that this is out there, all of the talk shows, all of the Fox News and its print equivalents and its online equivalents are up in arms about this. And one of the most striking things about this case that the ADF brought is the language. They deliberately crafted this with an eye toward it becoming a template for other states with really awful language, referring to Terry and Andrea as boys, as biological males, right on down at every opportunity, not referring to them as transgender women, not speaking on the merits of science, biology, but trying to be as hurtful as possible. When you go into court over something like this, is that important to the actual arguing of the case, or is that just a public relations thing, just stirring up opposition and hatred?
That's a great question. And it speaks to, I think, in part, something that is a major component of many of the cases that organizations like the ADF, like the ACLU, are litigating every day. And I speak primarily to cases that end up at the U.S. Supreme Court. The framing of a case, the language of a case, can be of critical importance. Taking examples from the LGBT plus community, 1986, the case of Bowers versus Hardwick that dealt with whether, as in my framing, dealt with whether anti-sodomy laws were constitutional. The court, the United States Supreme Court, in affirming those laws and upholding them, cast the case as, is there a constitutional right to homosexual sodomy? Fast forward to 2003, Lawrence versus Texas, that overturned Bowers. Question is, do couples of the same sex have the same right to intimate personal conduct as couples of not the same sex? Very different framing, different outcome.
Right. Who's going to vote? Who's going to be pro-sodomy?
Correct.
Right.
Correct.
But the right to intimacy between partners with romantic couples, it's an entirely different question.
Yes. I mean, you take the marriage question, what we're talking about here is dignity. What we're talking about here is equality. The framing and the language can really matter. So in this case, that is a similar circumstance where the language that's used in a legal sense, in a we are crafting this case for the long haul sense, matters from the get-go. And so the arguments from the plaintiff have been that is crucial to the case. To use terms like biological male is crucial to the case. The judge disagreed to some extent and put some limitations on how the plaintiffs could refer to Terry and Andrea and other trans athletes. That was, and I don't know if we may get to this, to the appeal portion of this, we're going chronologically, but that on appeal was a basis for the plaintiffs to argue that the case should be, if it went back, given to a different judge, because that sort of prejudged the case for him to require at a minimum level of dignity that they not refer to Terry and Andrea and others as biological males, but to kind of spoiler alert to the end of the story
come on,
thus
don't
far.
Ruin it, Michael.
That the case is going back to the same judge. So the Second Circuit didn't seem to find that argument compelling. So
language, I mean, I know that in general, language in the legal profession needs to be meticulously specific, but that's sort of playing to the crowd rather than to speaking to the merits of the case. And I just, I put myself in the position of Terry and Andrea and having to hear those phrases over and over and over. And it's, it's hard enough just to get through the damn day when you're trans, to have half the country using these terms that are designed to bring you down. It hurts my heart.
Yeah, it's tough as any litigant to go through that. I don't think enough attention is paid to the emotional labor that goes into bringing a lawsuit or just having to be part of one, because Terry and Andrea, of course, didn't ask for this case to be brought.
They just wanted to run.
They just wanted to run.
Yeah.
And it's other people who brought it, and they have had to just sort of endure this spotlight and attention that was foisted on them. But even if somebody brings a lawsuit, there's a lot of that labor that goes into it. Oftentimes, in the discrimination cases that I deal with, there's the initial underlying incident. Then there's, other instances along the way where you may have to kind of provide more information and talk about it to somebody who's drafting the complaint. Then along the way, there's other instances where you're going to have to dig into that again, and it can be really, really re-traumatizing. Yeah. And we try to work on ways to limit that, but it can be difficult just the way that our system is built. So yeah, this sort of language is difficult. It's difficult for individuals to hear just generally. It's difficult for lawyers sometimes to hear as well.
Because that must be part of your 9 to 5, 5 days a week. How do you keep yourself healthy?
It's a great question. We all, I think my colleagues and I, everyone who's involved in these civil rights movements has to have a way. And I tell this to students, when I go to kind of career fairs or work with interns. If you're going to go into this work, you have to find a way to manage self-care and be able to, and it's tough when you care about this, because you can't really just close your laptop at 5 and leave it aside, because then, if you go onto Instagram and somebody's posting about this thing that's happened, or you just happen to open up the news and see this thing that is affecting the community. And then if you're also on top of that part of the communities that are being affected, there's the extra layer of that. So for me, of course, litigating against the Alliance Defending Freedom that has been involved in seeking to take steps to limit efforts, to limit rights that affect me and my family and my community, there's a difficult sort of overlap that can sometimes happen. There's the professional challenges of any litigation, and then there's also the personal challenges of kind of having to realize these are the same folks, the same attorneys who are engaging in this as well.
So this goes on for about a year, a little more than a year, and then there's a ruling.
Yes.
And so this is April of 21.
The case is dismissed. A motion to dismiss filed by the defendants in the case is granted, and the case is dismissed. Okay. Now,
that sounds, on the outside, like nothing is resolved. So let me see if I can poke at it a little bit. On what grounds is this case dismissed?
Essentially technical ones, focusing on primarily the pleadings, whether the plaintiffs have kind of put forward a claim that can be heard, whether they have standing to bring these claims that can be addressed by the court, and whether what they're seeking is something that the court can properly provide.
So in this case, the fact that they were no longer students, that they had moved on past high school at that point, is that part of the fact that they no longer have standing? When it says they don't have standing to rule on this, is that because the kids had moved on, or?
So there's a component to that. By the time that we get to the ruling, the initial season has passed. And obviously insert into this COVID
right.
that arose.
Oh my goodness,
so,
yeah.
So that's, originally we were going into, and there was an impetus on the part of the plaintiffs to get this resolved, get an injunction in place, because we're going into the spring season, and then 2 months after the case is filed, there is no spring season anymore. And so then it sort of takes a bit of the time impetus off. But then by the time that we get around to, to a ruling at this point, I think at that point, and we're going back a couple of years now, but if memory serves, some of the athletes had already graduated out, and so having any kind of prospective relief is not going to serve them. And then, there's a lot of this gets into a little bit of the arcane sort of rules that go into bringing a case in federal court, and the justiciability of those cases, to throw out a long legalese term. But you have to have an active controversy to go into federal court, and you have to have some relief that the courts can provide. And so if it starts seeming like there isn't an active controversy anymore, or that there isn't relief that the court can readily provide for a variety of reasons, then the courts are going to start taking a little more skeptical view of whether this should be in front of them in federal court.
Mm-hmm. But then this case does not resolve some of the questions that seemed to be surrounding it. So, for example, it does not give a yes or no as to whether these cisgender athletes deserved compensation. It doesn't resolve what should be the policy of the CIAC, and is that fair or not fair? It certainly doesn't address the really broad questions of trans athletes in general.
Correct. It doesn't get to any of those sort of substantive merits questions, the ones that I think generate the most headlines about. It's the kind of decision that doesn't make, other than the fact that case is dismissed, it doesn't make for the easiest sort of, news article soundbite to be written about it. Requires distillation, requires, the news organization to bring in their legal folks to sort of parse out what it means, and can lead to a little, even among experienced lawyers, can lead to a little bit of head scratching and sort of sitting with for a while.
So then is it the Second Court of Appeals?
The Second Circuit Court of Appeals
picks this up again about a year later, maybe. Is that ambiguity part of reopening it that way, or how do you go from A to B? Is I guess what I'm asking.
When somebody receives an adverse decision at any sort of trial court level, the lower level of court, whether that's the United States District Court, which for federal courts is the first level, or in state court here in Connecticut, which is the Superior Court, if you receive an adverse decision, generally speaking, you can seek to appeal that to a higher level of court. And you sort of bring your primarily legal arguments to bear and say the court below got it wrong for these reasons. And so in this instance, the plaintiffs appealed. In federal court, we have they're called the Circuit Courts of Appeal. There are, I forget how many of them, though, maybe over a dozen of them at this point. You sometimes hear in the news the Ninth Circuit or the Fifth Circuit. Mm-hmm. And Connecticut, New York, and maybe Vermont as well are in the Second Circuit. So the plaintiffs appealed to the Second Circuit Court of Appeals. There is, more legal briefs. There's argument down in Manhattan, where the Second Circuit is based, and then there's an initial decision by a panel of 3 judges to affirm the decision of the district court dismissing this lawsuit. But that ends up not being the end of the story.
So the appeals court is saying that the district court was right in saying there isn't a here anymore.
Yes.
Okay. So that would seem to resolve everything, and everybody goes home, right?
It would, or at the very least, to set the stage for the plaintiffs as the recipients of this, what to them is an adverse decision, to petition the United States Supreme Court for certiorari.
So the Supreme Court would be the next step.
Ordinarily, yes.
Okay.
However, there is a somewhat less utilized middle ground between those, which is reconsideration en banc, which is when...
That's ENBANC.
Yes.
Okay.
Yes. Bringing back I guess there's maybe French in this instance. But it's the whole court, the whole Second Circuit. So normally appeals are heard by 3 judges and decided by a 3-judge panel. But reconsideration en banc means the whole Second Circuit, all dozen-plus judges getting together and rehearing the issues. Now, a lot of times that's something that the parties will request. In rare instances, that may be something that the court itself, on its own, of its own accord, orders to happen. Very little of my practice is in the Second Circuit Court of Appeal, so I've had to ask around, but it seems a very rare occurrence in the Second Circuit to have any kind of reconsideration en banc, much less a court-initiated reconsideration en banc. But that is what happened in this case. No party requested it, but the court itself ordered that there would be reconsideration en banc of certain issues.
Within that.
So
what are the possible outcomes? Has that en banc thing been resolved? Oh, it has. Okay.
Yes.
So
a decision was made on what I think are sort of narrow grounds. A majority of the en banc panel of judges to reverse the initial 3-judge panel and reverse the district court and send back to the district court for further proceedings, basically concluding that the plaintiffs had at the very least alleged enough to establish standing and an injury that the court could consider. And at the very least, sort of on a timing and procedural basis, that the court didn't have to determine at this early stage of the proceedings that we were in, which, mind you, 4 years in, we're still considered to be in early stages. The wheels of justice turn steadily but slowly. That at this early stage, the court doesn't have to get into, some of the finer details of the possibility of whether there's liability for damages, monetary damages, before deciding whether there's at least a claim to be made for those. And it's interesting because at this stage, given the issues and the way that the case was presented, in some ways both the court itself and the intervener parties, the ACLU on behalf of Terry and Andrea and the CHRO, were sort of in a different posture than the other defendants insofar as we had a concern about if this was a case that was brought by transgender athletes seeking to contest a policy that prohibited them from being able to compete in accordance with their gender identity, that tried to deprive them of opportunities, would they be able to get into court to make some kind of a claim? And ultimately, this decision allows that sort of claim to be able to be brought if it were to come to that. And I think maybe this is just me, but I think it's interesting, as a sort of maybe a personal note, a historical note, the author of this decision was I think the Second Circuit has the first 2 lesbian judges in the federal circuit courts of appeal. The author of this decision was the second of those. And she, along with the first lesbian circuit court judge, took the unusual step of writing a concurrence to a decision that you very rarely see the author of the decision for the court writing a concurrence to their own decision, but we have that here, sort of noting that point that the court had in mind the idea that the doors would remain open for a trans athlete to be able to bring a claim as well. And also noting, which I thought, again, was an important consideration, sort of what we spoke of a little bit ago, which is putting aside the legal issues in this case, at the end of the day, these were high school kids.
Right.
Seeking
Yeah.
to just run track, you know?
Right. And all of the ancillary benefits of being part of sports
Yes.
when you're in
Yes.
high school. The ability to develop team skills and leadership skills and that sense of self-worth that comes from running a good race. In addition to, because one of the things that seems kind of double standarded to me about this is the fact that there was a third trans athlete, and I don't remember if it was on Terry's team or on Andrea's team, Ariana Brown. And it seems like everybody's fine to just let things play out the way they should play out in high school until the trans women start winning. That because Ariana was a terrific runner, but was down around number 5 or 6, whereas Terry and Andrea were winning things. This name doesn't get mentioned anywhere. It's not a big deal. Likewise, it seems that the issue of trans masculine people competing in sports doesn't seem to bother anyone except for the Mac Beggs case, which was just a travesty. So there are a lot of different avenues that aren't specific to this case, but that's got to be hard for you as you're mapping out, because this is wherever this case goes, it's precedent, right?
Yeah, there's a definite intersectionality that exists and sort of layers of intersectionality that cannot be totally put aside, even though sometimes the soundbite narratives don't account for that. For example, some ways that this case is portrayed in a very concise way suggest that, overnight Terry and Andrea, came out and then started winning everything, right? Like they came out, joined the girls' team, and started winning everything. The record seems to suggest that that's not the case, that there were instances where some of the plaintiffs won races. And then there's also, as you said, this extra layer of, okay, there seems to be this extra policing of trans women.
Yes.
In some of these instances, and we see this not just in the United States, but internationally, how much of this is particularly policing trans women of color.
Mm-hmm.
And isn't this a subset in some ways of the larger policing of women's bodies more than men's bodies? And you can't, even if a case in the way that it's pleaded and framed doesn't necessarily draw in all of those factors, in my view, you cannot totally ignore them or remove them from some component of the calculus of where these cases go.
Yeah, absolutely. And I mean, you used the word intersectionality. That is very much at play here, because one of the facets of this discussion is what kind of puberty did you go through? And that if we were to make puberty blockers available to kids for gender-affirming care early enough, then they wouldn't have gone through an endogenous puberty, the male puberty, as the language in these bills would say, where this alleged advantage that trans women have, that's no longer an issue. It's the fact that for a number of reasons, we can't get gender-affirming care to the kids who need it. And that crosses lines of race and income and medical history, right? So, if you can't afford HRT, if you are, as a kid, if you are in a family where the adults do not support you transitioning and are going to wait until after your puberty to let you have access to that, all sorts of sub-issues that come up. And this, again, going back to the language that the ADF used, this idea that it's a one-size-fits-all, trans women equals bad, is just bulldozing over so many nuances that need to be discussed.
100%. And you're exactly right. You have to see the whole board, right? Because part of the argument is, well, we shouldn't have trans athletes competing, particularly trans women competing on the girls' team, because they've already gone through, as you in quotes, male puberty.
Yeah.
And so then, if you're confronting that, you say, well, okay, then how about puberty blockers? And well, we can't. It's too early to let kids have puberty blockers at this age.
But it would solve the problem. You're all up in arms
right.
about.
How do they even know? How they identify at this point? It's like, okay, well then why don't we start having conversations about how trans people exist and how these conceptions about gender at in an age appropriate way. Well, no, we can't talk about it at all.
Yeah.
We just cannot even.
Yeah, you can't. That's inappropriate.
That's right. And so you start taking these steps back and back and back, and then you realize that the inference that I draw is that actually you don't want them to be able to participate at all.
Right.
You don't that it's not really about this one specific thing, because if you start going backwards in the chain, you see that there's actually every single step of the way. Yeah. And that doesn't even get into, like you said, all of the other ways that people are deprived of these opportunities in some states. For example, if you are reliant on sort of the state healthcare system,
healthcare,
those efforts, like the even if in some instances the federal government would require that gender affirming care be covered by like the Affordable Care Act plans or under the state health plans, maybe the less supportive legislature or executive has decided that they're not going to cover in these instances, and so that closes the door there. In some instances, some communities, the primary provider is potentially a religious-based organization that has made a determination that for religious reasons they're not going to provide this. So there are all these layers, right, that exist that lead to kind of the end point, which then you may see in a case. But just because the case sort of provides a snapshot, but it doesn't necessarily tell the whole.
Whereas the totality of it is a movie.
Yes.
You're looking at a snapshot, but really this is something that occurs over time. It occurs, in ways that intersect with so many other complex systems that don't have simple solutions. Right. It feels as if litigation is antagonistic and it is zero-sum. Is there room in this for educating the judges? I mean, I've got to imagine that it would be pretty easy to walk into, say, that the full en banc thing and have 95% of them really not know any of these nuances that we're talking about. So is there opportunity for you to educate as well as argue?
I find that the answer is yes. It is. I find that it's more difficult, however, in federal courts, particularly at the appellate level, just because the time constraints are much more severe. So in some instances, you get 20 minutes, to really lay out this whole case that maybe has been going on for years. And given the wide breadth of the issues that may arise in federal court, you sort of have to rely on potentially having educated the people involved, the decision makers involved, the judges and their staff through written arguments. So before you get up in, even at the U.S. Supreme Court, we often will, hear sound bites on NPR or wherever else about like the audio of the court decision. But it's not like that's the first time that the judges are hearing about the case. They've already gotten the benefits of, and their clerks and staff have gotten the benefits of the written arguments. So, I do find, though, that part of my job is to educate to some extent. And, I think that there's also some component of judges having that in mind as well. Justice Elena Kagan often talks about how, she hasn't put aside her, she used to be in academia, and, her decisions often read as though they are meant to sort of teach people about the issues, to be accessible to a non-lawyer. and to be accessible to either law students or less experienced lawyers coming to the issue, or members of the public. I heard once a judge in Connecticut, Michael Sheldon, a former appellate judge, say, great lawyers are great teachers, because whether you're in front of a jury or you're in front of a judge who may not be as familiar with the issues, there is some educating that goes into it. Sometimes that can increase the emotional labor, right, that you're taking on, especially if you are somebody who's part of a community that's affected. You may be having that emotional labor in your private life and then also in your public, professional life. But for the most part, I find that judges are very receptive because they want to make the right decision. At least the judges that I've appeared in front of. I can't speak for all of, I can't generalize in that way, but the judges that I've appeared in front of, they want to make the right decision. They want to know. And, once they learn the first time, they're not going to just erase it the next time. Usually they're, once you've kind of gone through that once, then if they see that issue again in the future, they will hopefully come into the case with that knowledge.
I want to come back to the Supreme Court in a second, but so what happens next with this particular case?
So we've come back to the district court, and we are going to have to essentially revisit these early stages, whether that's sort of updating the pleadings, updating the complaint to reflect where we are now.
Right.
And then sort of taking on whether that complaint is viable and can go forward despite what, the decision that's been made so far, the return to this case, making sure that it still satisfies that. And then potentially it goes on its way, goes through the process of any federal court litigation, which is you spend the first period of time sort of tackling whether there's any deficiencies in the claim or the standing of the plaintiffs to bring it. And then assuming that is resolved in a way that the case remains alive, you potentially get into discovery, you potentially start deposing witnesses, you obtaining documents, and then eventually potentially a trial. And then after the trial, potentially you get a decision, and then potentially then you end up on appeal again, and then you go on your way. It can take quite some time.
That just sounds prohibitively oppressive.
Yeah.
How does it change the tone of what you're doing, knowing what the current composition of the Supreme Court is, and the fact that it seems to be politically motivated in a lot of ways that maybe it hasn't in the past? Certain things like the issue of LGBTQ rights seem to be a foregone conclusion with the current court, that would not go our way. Does that change the way you and the ACLU approach things?
I can't speak for the ACLU. For my part, it doesn't really, on a day-to-day basis, because number one, we are still, we were for a while, and we are now back in this sort of local sphere, right? So it may be that some attorneys are sort of just dropping into Connecticut, for this case and don't have to. But from my perspective, as a Connecticut attorney, as an attorney for a Connecticut state agency, this is our sort of home neighborhood. Right? These are the judges who we are going to practice in front of. This case involves our communities, our school districts, our students, our policy. So I am focusing on the immediacy of that, this court. And maybe that's because I've never practiced in front of the U.S. Supreme Court, so it seems such a lofty place, for me. It's so far removed from my day-to-day versus, for example, the Connecticut Supreme Court is much more something that's within, my sphere. But so I'm not, focusing on that as much. And that, I don't think the judge who is currently presiding over the case, and not this judge specifically, but any judge who's currently presiding over the case wants to sort of be spoken past. They don't necessarily want to have you foregoing the current thing, speaking to, the future justice,
I want to talk to your manager.
Yeah,
I want to talk to your manager.
The legal judicial equivalent of,
don't say it. My best friend has that name. So
I'm not gonna. But like the legal equivalent of like foregoing the person who's at the counter to like go to, no one appreciates that, and I certainly don't want to be the person on that end of it. But some of these organizations are operating kind of pretty constantly at this macro level. So sometimes it may feel like that's happening, that decisions may be being made, that things are being framed in a way that is for the long haul of, looking ahead to where this case may end up. From my perspective, it's much more removed than I sort of act on a day-to-day, but on a state level basis, which is a little more immediate, there is some at least consideration of what could happen in the future. The other thing too with the U.S. Supreme Court is it's really tough to predict, where things will end up. So even if you think you have, with this sort of majority of a court, we got, the Bostock, decision that said that for Title VII, the federal employment discrimination statute, when it references prohibitions on sex, that encompasses prohibitions on sex discrimination, that encompasses prohibiting discrimination on the basis of sexual orientation and gender identity. An opinion authored by Justice Gorsuch, right? It's difficult to predict and say for sure how this will end up. Certainly, we have seen a certain tenor of decision coming from the U.S. Supreme Court, but maybe this is just lingering optimism and naivete. I'm not ready to totally throw in the towel on assuming that if the issues in this case were to reach that court, that there would be a definite and predetermined outcome.
Well, that's good. I'm glad to hear you say that. Is this argument that you are now it sounds like chained to for the rest of your life. Is this happening in other states?
Yes.
Other states that have whose athletic bodies have supportive of trans athletes?
I know that there was another case that the ADF was involved in out of Idaho that went to the Ninth Circuit. There was a brief period of time where it seemed like there were a lot of these cases that, or at least a few in different states that were popping up. I don't know if it's just simply the interruption of COVID and just the wheels of the legal system. The momentum has seemed to have paused on that. Part of it could also be that they have been able to obtain legislative victories.
Yes.
So they've been able to accomplish things in those ways without having to resort to the courts. But I know of at least one or two other cases in other states that, again, in federal court that have focused on this issue.
I really appreciate your time coming here to tell us about this today. This was nice to be able to sort of parse things out.
My pleasure.
Anything I forgot to ask? Anything you want to end with?
Just that whatever happens in this case, and as folks hear about a lot of things happening in other states, I like to remind people that Connecticut still has protections, that there are many protections that are enshrined in Connecticut law for many protected classes, gender identity and expression being one. So that, and many other states have enacted those protections as well. So though federal litigation, U.S. Supreme Court decisions, the actions of Congress or inactions of Congress may generate the loudest headlines, at the state and local level, depending on where you live, things may not be as dire as the headlines may suggest.
Coming up next on Transqat, I speak with Eric Orner, who wrote and drew the graphic novel Smat Guy, The Life and Times of Bonnie Frank. I loved this book, and I really enjoyed talking to Eric about his work and the man, the legend, the congressman himself. I attended Guilford Pride last week, and the weather was not so good. Cold and rainy all day, despite forecasts to the contrary. Good to see some friends and former guests, though. Hilary Weisberg was there, the Reverend Riley Page, Tony Ferriolo, Sarah, Stacy, and Lynn from our parenting episode this season. Look for Transqat at Middletown Pride on June 1st, Boston on the 8th, Killingworth on the 9th, and Rhode Island on the 15th. In addition to recording people telling their stories, I'll be offering a chance to play Pride Bingo. Hashtag Death by Bingo. Stop by the tent and check it out. There is still time to see the new musical A Complicated Woman at the Norma Terrace Theater. Get tickets at goodspeed.org. I've seen it twice all the way through, and we'll be seeing it a few more times before it leaves on the 2nd. This musical makes me sing and laugh and cry every time. The cast is incredible. Get out and see this show before it heads to Broadway. And lastly, the Outfilm CT Festival is June 14th through the 22nd. Come see some wonderful films. The shorts programs are always my favorites. And hang out with like-minded folks. More info at outfilmct.org. This has been Transqat. I am Clare McCarthy. Thank you. Thank you for listening. And let's talk soon.
This is Sadie McCarthy. I'm Claire's niece.
And you've just been listening to Transqat. It is made by one of my favorite people in the world, Clare McCarthy.
Transqat is a production of Transqat Enterprises, LLC.
Copyright 2023, all rights reserved.
Join us on the web at transqat.com.
That's TRANSQAT.com.
QAT.com.
QAT.com.
There you'll find links to Transqat, the blog,
writing projects,
speaking engagements,
and our PayPal donations page.
Please consider supporting our mission with your monkeys.
Monies.
Your monies.
Your monies.
Not monkeys.
Please consider supporting our mission with your monies. Any monkeys will be gratefully received as well.
Follow Transqat on Instagram, Facebook, Twitter, and YouTube.
On TikTok, we are at The Real Transqat.
Want to tell your story on air?
or ask Claire a question.
What is the deal?
She has all the answers.
Or suggest a guest or topic for an upcoming episode.
Use the contact page at the website
or email her directly at crmtranscat@gmail.com.
crmtranscat@gmail.com.
And thanks for listening.
Thanks for listening.
Thanks for listening.
Thank you for listening.
Thanks for listening.
Thanks for listening. Bye.